Alright, so I was scrolling through Facebook the other day and I came across this post and I thought to myself, is this true? Can police officers no longer search vehicles based off of the smell of cannabis? Well, the real answer coming up. Hello, my name is Clyde Guilamo and I am a lawyer in the Chicagoland area, and in Law Talk for Non-Lawyers, we talk about the law in plain English. And in this video, we're going to talk about Illinois' sniff and search law, or stated differently, whether an officer can search a vehicle based off of the odor of cannabis. Now, this very question was answered by the Illinois Supreme Court back in 1985 in a case called People of the State of Illinois versus Stout. In that case, an officer was on patrol when he observed a vehicle commit an illegal right-hand turn. The officer decided to stop that car, and it was Mr. Stout who was the driver of the vehicle. As the officer was talking with Mr. Stout, he smelled the odor of cannabis coming from Mr. Stout's vehicle, so he decided to do a search of the vehicle. During the search, the officer found cocaine, a controlled substance. The defense attorney who represented Mr. Stout in that criminal case saw that the cocaine was found as a result of the search and decided to challenge the search, claiming that it was an unreasonable search and a violation of Mr. Stout's constitutional rights. And that's actually going to begin our legal analysis. Your right against unreasonable searches is actually governed by the 4th Amendment of the United States Constitution, and that protects you from unreasonable searches by the federal government. It's through the 14th Amendment that applies that protection to state and local actors like the local law enforcement, your police officers. During the 1960s and 1970s, there was a huge hippie movement in the United States, and that really opened up the use of cannabis to the masses. Okay, it was becoming a lot more common for people to use cannabis. Well, not only was it becoming more common, but it was also more common for police officers to interact with people who had recently used cannabis. And this was one of the issues that was going on between the 60s, the 70s, going into the early 80s. Now, in Illinois, different courts had treated this situation differently. According to the 2nd, 4th, and 5th district, they felt that the smell of cannabis by itself was enough to justify a search by a police officer, okay? But the 3rd district said no, the smell of cannabis is not enough. Now, if you've ever been near someone who has recently smoked cannabis, you know that that smell lingers long after the cannabis is all done. So one of the questions was whether or not this smell is enough to justify a search of a vehicle. Now, because there was a split in the lower courts between the 2nd, 4th, and 5th going one way and the 3rd going a different way, this case came before the Illinois Supreme Court, that being People versus Stout. And what the Illinois Supreme Court decided was that the odor of cannabis alone was enough to justify a search by law enforcement, okay? So police officers can search a vehicle if they smell cannabis inside of that vehicle. Now, this was the law of the land up until 2016, and in 2016 the legislature in Illinois passed a law allowing for the use of cannabis for medicinal purposes. Once that happened, more contact between law enforcement and individuals who smelled of cannabis were occurring, and a new case went before the appellate court in Illinois, that being People versus Rice. They wanted to challenge whether or not the smell of cannabis would still justify a search by law enforcement. And ultimately, the Rice court decided that People versus Stout was still good law. Officers can still search vehicles based off of the smell of cannabis alone. But in 2020, we had a new change in the law, and this was now the recreational use of cannabis by all adults over the age of 21. This once again leads to more and more contact between law enforcement and individuals smelling of cannabis. So the question once again in 2020 went back before the Supreme Court in a case titled People of the State of Illinois versus Hill. Once again, figuring out whether or not the smell of cannabis alone was enough to justify a search. In that case, the Supreme Court saw that it wasn't just the odor of cannabis alone. The defendant took a long time to stop before the officer performed the traffic stop. The officer was also able to see some loose cannabis. So in People versus Hill, the smell of cannabis plus these other items made the search reasonable. But one thing that's interesting for us who study the law is that, generally speaking, the Supreme Court cites to earlier cases, and the pivotal case on this very issue is People versus Stout. But when you review that case, People versus Hill, the Supreme Court doesn't cite People versus Stout as authority. So we're left to think, is this the new standard? This smell of cannabis plus other items? Or is the old standard still in play? That being People versus Stout. And you know what? Until a case has been overturned, it is still good law. So we can opine as to why it is that the Supreme Court did not rely on it, or did rely on it, but just didn't put it in its actual case. But ultimately, the end of the day, People versus Stout is good law in the state of Illinois. So what that means is this reporter completely got it wrong. The smell alone is still a valid basis for a search of a vehicle. Police officers can still search a vehicle if they smell cannabis. That is from the Supreme Court case of People versus Stout. A trial court's finding that there was no probable cause on an individual case, that is not binding authority on anyone. It's not binding authority on you. It is not binding authority on me. And that ultimately just means that we may be ready for a shift in the law, but that shift has not happened. So if any one of your friends, if anyone you know has seen this article and is passing it around as if there has been a change in Illinois, please let them know that is not the case. Refer them to this video so that they can know that it is still good law, People versus Stout. So in summary, the smell of cannabis alone is still good law in the state of Illinois for giving officers the right to search your vehicle. In a recent court case, which was People versus Hill, that went all the way up to the Supreme Court, they sidestepped the issue. They said there was the odor of cannabis plus other items, but they did not overturn People versus Stout. So officers can still search your vehicle based off of the smell of cannabis alone. Okay, I hope that was helpful. For my lawyers out there, if you're interested, I'm actually going to put in all the cases, the citation to the cases that I've used for this legal analysis. You can go ahead and refer to that if you ultimately want to file a motion to suppress. But for my viewers out there, please know that this article got it completely wrong. You should not follow it. You should not share it, because ultimately their theory that officers can no longer search people based off of the smell of cannabis, they are flat out wrong. All right, take care, guys. Bye-bye.